So we're going to go ahead and get started because I know tonight's session, we still have a minute, so I'm going to make a few announcements. But I want to welcome everybody to tonight's SALT Talks. We're doing our second attempt at a hybrid session tonight. So bear with us if there's any technical difficulties. we will work around them if we have to. So for those who don't know me, my name is Patty Schramm. I'm the Parent Resource Trainer Coordinator for the SALT Talks. We're here tonight. This month in April, we were talking about the whole month. The theme was, I'm stuck. Who do I ask? And so we worked in tonight. We have ldrake here. Hi, Laura. She's here to talk about guardianship and the alternatives. So one of the things that a lot of parents, a lot of us get stuck on is when we get to that age, when our child gets to that age of 18 or an adult or, somewhere along that line of transition, these are decisions that we have to look at and face. Will we need guardianship? Don't we need guardianship? That's a very confusing decision to make. So we're hoping tonight's presentation will help you sort through some of those decisions. We have Laura here. She's presented many times for our SALT program. She's great at answering questions. For those who are attending online, if you type your question in the chat box, Laura, do you want me to read off the questions as they come up, or do you want to wait till the end?
I'm fine with either way. Can you hear me, Patty?
Yeah, okay. I can hear you.
So I'm fine either way, whatever. If it makes sense to during a pause, that's fine. Or if you make sense to wait, that it doesn't matter. I'm good.
Okay. So if you type your question in the chat box, I'll try to jump in there at whatever time during the presentation and ask your question. Once we finish the presentation tonight and I turn off the recording, we can open it up for a full discussion. But for right now, if you can type your questions in the chat box, that will be great. So also I wanted to make note for those who are attending online, they can see the link for the survey that we're putting out there. We're going to be closing the survey at the end of this week. It's just for input about next season. For those who are there in the room, you just go to our SALT Google Drive. It's in there. If you go to Live Binder, it's also in there. So, and you can just take it anonymously. You can ask questions, whatever on that, and give your input. So with that, I'm going to turn it over to Laura. I think you're all set, Laura. We can hear you here. And I think your screen's advanced okay. So go ahead and I'll turn it over to you.
Great, thank you. There's only one problem, which is that on the screen here, you can't see it because there's the pop-up about it being recorded, and I do not know how to get rid of that. I'm afraid to mess around with this too much.
It's up in the corner, right?
No, I mean, I can't see it at all. It's just on this. I can see. Let me see if I do this.
Because it's just to the side for us. We can see it on.
I got it. It's in the middle of the thing. I got it. I found it. I found the little thing.
Yeah. Okay. We're still.
That might go away. Hold on one second, guys. Sorry. I'm going to get this taken care of. I can see it, but I can't make it go away.
It's in the middle of the screen?
Yeah. Okay. I got it taken care of. We're good.
Okay.
I think. Hold on. Now the presentation is gone, but we're going to fix that one. There we go. There. Perfect. Okay. Great. Hi, everybody. My name's ldrake. For the audience here, if you have a question, just raise your hand and let me know. For online questions, as Patty mentioned, people are going to put them in the chat and she'll read them to me because I can't actually see those. But she'll interrupt to let me know. And there we go. So I'm an attorney here in this area. I live in Cincinnati. I live in Blue Ash. And I have been working with families who have children with disabilities for, I guess, almost 15 years now. And I grew up in this world because I have an aunt with a developmental disability. And so, and my mom was her guardian, and had she lived longer than my mom, I would have become her guardian. I was her backup. So the thing about 20 years ago now, when HIPAA, the Health Insurance Portability Act, and all that came into effect, and doctors were requiring that you had that you be, approved to be in the room. We can't release private confidential data unless you have some sort of authorization to be in the room with your child during your adult child during a medical procedure. There was a massive push to get that parents should become the legal guardians of their adult children. We don't do that anymore. We don't make that push. And so the way I always like to start this out is that your child, you know them better than I do, and you're going to need to realize what their needs are. But you shouldn't be pushed into obtaining guardianship over them until you're sure you need it, because it's a process that once you start, you really can't undo it very easily, because you have to prove that the disability has gone away, and that's usually not something we can prove in this world. So it's the kind of thing that I always say, like, listen to what the alternatives are, see if they're going to work for you, and if they are, try them. You can always escalate to something greater if you need it, but we've moved in this world to supported decision making and alternatives to guardianship, and so that's what I want you to think about. So you're automatically the guardian of your children who are under the age of 18. It's called you're the natural guardian. You get to make the decisions for your kids under 18. That's not a problem. After the age of 18, for you to be able to make the decisions on behalf of your adult children, you would need the probate court to name you as their guardian. And then that gives you the up to the complete power to make those decisions. But until a probate court has determined that your adult child is incompetent, they are competent. They are able to make their own decisions until the court says otherwise. Now, sometimes we have doctors say, well, I don't believe they understand the decision-making process, and so we won't accept we won't accept it. But those are in emergency situations, all right? There's always an emergency option out. But for the most part, everybody else has to presume that your child is competent until a probate court makes a determination that they are incompetent. So you're their guardian until they're 18. If you decide that you need to become the guardian, well, then you're going to have a present need for a guardianship, right? The court has to determine that there's a need for that. It's very easy to prove that. If the need is, if they have a medical emergency, they can't explain what needs to happen. So I need to be named the guardian because a medical emergency can happen anytime. And then the court has to find that person incompetent, and that person is actually called the ward. If there's a guardianship in place, they're called a ward. And the way it starts is a doctor has to file a statement of expert evaluation that says this individual is not capable of making their own decisions. If the doctor won't sign that, if you cannot find a doctor to sign that, you're never going to get guardianship. Okay, it's not possible. So that's the end of it. When people call me and say, oh, I need to get guardianship, like, here's the form, get the doctor to sign this and we'll talk. Until then, there's no point. It might not be necessary. It might not be needed. And then even after that, the doctor signs this form, you file the paperwork with the probate court, and then each court has an investigator. And once upon a time, that was kind of pro forma, not so much anymore. They come out and they're going to talk to your adult child and ask them questions and make a determination whether or not the investigator thinks they need a guardian. That's the next step of it. So there are two people outside your family who are going to have to say there's a guardianship needed before the court's going to even consider to move forward with it. And if either of them say, I'm not so sure about this, the guardianship's not going to happen. So people think that they need guardianship because oftentimes you've been told so, right? The schools will tell you, or a doctor or a hospital will say, you need guardianship after they turn 18 to be in this room because they're not going to be safe if you don't. Maybe there's, you want to be able to access information, control like a stable account, things like that. You want to be their representative to deal with Medicaid, Job and Family Services, to help them get the county DD board, or you want to help them handle their money. And again, I think families have been told guardianship is the way to do all those things. To be clear, there are alternatives to guardianship for all of these. You don't have to have guardianship to be able to do these. So it's kind of handy sometimes, but it's not necessarily what the best route to go. And the reason I think guardianship should be looked at as a later resort, I'm not going to say it's the last resort, but it should be a later resort, is that once, the court has to come in and determine that they're incompetent. Most courts around here are pretty good about it. So for senior citizens who are deemed incompetent, it can get kind of hairy. Generally, I see when they're having a conversation with somebody about a developmentally disabled individual who needs a guardianship, most of the magistrates and judges are respectful in how they ask the questions, so that makes sense. They will talk to the child, again, the adult child. Is this your parent? Do you trust them to make decisions for you? Do you think you could use help making medical decisions and things like that? But some magistrates and some judges, the language that they'll use about obtaining guardianship can be, quite honestly, demeaning to the individual. And so, and in those counties, we tend not to bring the adult child with us to the hearing. Like Butler County, and I mean, Claremont County requires that the child come to the hearing, but the magistrates there are so nice about it that it's not a big deal. I mean, never, they're actually quite sweet about the whole thing. Hamilton County doesn't require it. So, so different counties have different rules on that. So first of all, the court has made a determination that the person is incompetent. They can't handle their own needs. And when they do that, they remove most of their decision-making authority. You, the guardian, have the final say on what's going to happen in their life and not the individual. And that's a pretty big deal to take that away. All of the responsibility regarding decision-making has been moved to this third party, you, right? And you, in answer to the court, you'll be given like rules as if you're the guardian, how you have to behave and things like that, what you have to take into consideration. But it's really now between you and the judge about what your role is in that. The individual, the ward, their rights have been cut off. Not all of them, but it's limiting them. They could even potentially they could take away their right to vote. It depends. They can take it theoretically. They take away the right to marriage. Depends. But their rights have been limited, right? They no longer have the capacity to enter into a contract. They don't have the right to do those things anymore because the court has deemed them incompetent. And again, once the guardianship has been established, as a rule, you have to show that the incapacity has been removed, it's been resolved to undo the guardianship. So if you're in a car accident and you bump your head, we might need a guardianship, and then you get better and you can show I'm better now. The consequences of the concussion are gone and I can handle my finances and make my own decisions. That's different than when you have a developmental disability. Those usually aren't going to disappear, right? We don't have any expectation of that. Yes. So the question is, if you have divorced parents, can they both be guardian? And the answer is yes. Overwhelmingly around here, yes. Most of the judges around here allow it, up and until the parents disagree. The judge is not going to mediate, and if the parents cannot have a consensus on it, they will name one or the other. Or if it's really bad, if it's like a constant fighting, they'll name a random third party. I mean, it won't be a random third party, but they will name somebody else. I've never seen them do that. I've historically, most parents understand if they're going to the court to fight, the court's going to pick a winner. So, but yes, around here, all the counties around here allow parents and divorced parents to act as co-guardians. There's some counties out east, like they don't do it, but around here everyone does. So, but the idea that once it's established, it's very hard to end matters for two reasons. One, that it's limiting their rights for a long time, but two, who's going to take over the guardianship when you're not here anymore? So part of the process of I need guardianship, in my opinion, is thinking, who's going to be the person who takes over in the future for that? So, and it's a little bit, it may be complicated to find a guardian in the future. So we see guardianship sometimes used to overprotect or control. I don't like who my adult child is hanging out with. I don't like that boy. I don't like that girl. I don't like them being around. I'm going to get guardianship, and I'm going to keep that child away from my child. I'm going to keep that person away from my child. And that's true. You can use guardianship for that. You can. It's a very effective tool for that. It might not really be your right to do that. It might not be the best way to handle that, right? There might be other ways of handling that. And the push now is in supported decision making, right? That's the idea that, and it's true. I had a friend who was a very high functioning autistic, very high functioning, and but his parents never helped him learn to make decisions. And after they passed away, he was just stuck because he didn't know what they would do, and so he would be told, I don't know what they would want me to do. And he just couldn't make a decision until he was backed into a corner. And you see that because they were not his guardians, but they were able to control him and not help him build up the skills to make his own decisions. And so the idea is that even as a even if you get guardianship, but before you get guardianship, if you help teach your child how to make decisions and explain why they need to make their own decisions, they can get better at it. And that's why guardianship is considered kind of a last resort, because we want them to be making their own decisions long-term when it's possible. And just for the record, there are lots of times that guardianship is really the only route. If you have a completely nonverbal child, you're not going to have really many other options to go but guardianship. And I get that, but I want to discourage it. Even in those situations, if there's another form of communication for them, I want to suggest that guardianship should, again, be something that we don't jump into. But oftentimes we use guardianship for HIPAA and IEPs in the schools and IP plans with DD. There are other mechanisms to deal with those. You can get a healthcare power of attorney, and then you can access the stuff with HIPAA. You can be in the doctor's room. You can, at the schools, you can have your child sign a form authorizing you to, they're 18, they can sign a form saying they want you in their IEP. The DD, the county boards, they have a form that your child can sign once they're 18 so that you can be involved in the decision making. If you're dealing with Medicaid, there's an authorized representative form. Same with Social Security, you can become the representative payee. There are all these mechanisms out there that give you the same rights guardianship would give you, almost the same rights, without the finality and permanence of guardianship. So again, I think the big push behind guardianship that happened in the 1990s and early 2000s was because of HIPAA. Everyone freaked out. Yes. So the question is, if I don't get guardianship at 18, is it going to be harder to get it at 20 or 21? And the answer is no. I have clients I have people who didn't bother to get it because they didn't really feel the need, and they end up getting it when their adult child is in their 30s or 40s. And the court doesn't care. The point is that you now have, usually people are trying to get guardianship when they've run into a barrier and they need guardianship. And you just explain to the court, I can't do this because I need to be guardian. So the healthcare power of attorney gives you the ability to answer and give consent for a procedure when the child isn't able to speak, right? Or isn't responsive about it. So there's a woman who never got guardianship for her child who was now 38 years old. Her daughter fell and broke her arm. It wasn't like a compound fracture. It wasn't through the skin. It was just a simple, easy break. And they took her to the hospital and they said, this is what we're going to do to set it. We need to do this. Do you give us our consent? And she goes, no, I don't want to do that. And they were like, wait, what? And her mom, everyone was like, here, no, it's not a big deal. You just have to do this, and it's not going to hurt very much. And blah. No, I don't want to do that. I don't want to do that. And they were just like, we can't do it. She won't consent. And again, now here's the thing you have to understand. She's not bleeding. She's not going to die. They do it if they're going to die. They don't care about it. It's just, their goal is to stop you from dying. And so they just, right there at the hospital, they filled out the paperwork about she needs a guardian. And then the mom, it was during Monday through Friday, she walks over to the probate court, gives them the paperwork. The investigator walks out, her daughter was with her. The investigator talks to the daughter, and they gave her an emergency guardianship right then and there. So, and then she went back, and now she was emergency guardian. So now she said, I consent to this. And they set the arm. And now after that, the mom did convert it to a full-time guardianship because she was like, I never really thought my daughter would say no like that. And okay, we have a problem. But up until then, she'd gone, really 20 years without it being an issue. And the court and everyone else recognizes what it is and they understand. So it's not a big problem. So HIPAA, you can have a healthcare power of attorney, and I recommend that. It doesn't have to be signed. It can be an X. It can be any kind of mark they make, or they can give consent at each meeting, at each doctor's appointment, not in writing. And the doctors are supposed to accept non-written consent, a verbal consent, or an indication. So you don't have to have guardianship just to deal with HIPAA if you want to be present. The only time in medical care that you have to have guardianship, again, is if your child is saying, no, I will not authorize that treatment. You can't override that with a healthcare power of attorney. That's the only way you can do it, is through guardianship. As I said, decision-making is a learned skill. And if we don't give people the opportunity to exercise that, they will not learn it. So a lot of it is making them understand the risks and benefits of a decision. And again, it's your child. You have a better idea than I do whether or not they can understand those consequences. And I also always like to kind of say, sometimes also there's like the teenage years, right? Where some of the kids kind of outgrow that. And so sometimes during the teenage years, we want, which, the teenage years, let's face it, last for everybody into their 20s. It doesn't have anything to do with being developmentally disabled. And so when you want to have that greater level of control at that time, you might think I need this guardianship, but they grow out of it as they learn how to make decisions better, right? So that's why I always am still suggesting, even if they're really difficult at that time, you might want to take a step back and see, is it really necessary? Because this is important to know. You cannot file for guardianship until after your child's 18th birthday. So no matter what, there's going to be a period where you're not their guardian. You cannot file the paperwork until they've turned 18. And then it could be 6-8 weeks easily before you have the initial hearing. Butler County was the problem for a long time. Like, they were months behind. I don't think they are anymore. I don't practice there anymore because they were months behind. Very annoying. And the clients would call me yelling, and I'm like, not my fault. I filed it. I'm out. I'm done. I've had one case since the new judge, and I'm like, and I'm still. It's funny because I won't practice in Butler County. I have other friends who won't practice in Claremont County. We have counties we just won't go to, and mine is Butler. So, but it can take a long time to get that hearing. And then even at the hearing, then they grant it. So you're going to have a period without guardianship anyway. So, it's not going to change too much. There is an emergency guardianship process. I will say it's changed. It's not used very often. But anyway, we're going to talk now about some of the alternatives about guardianship, because we're always wanting to think about what's the least restrictive support that would be there. What's the least restrictive way I can have control? I can assist. There are two types of guardianship, which we'll talk about again and later. One is financial and one is for healthcare decisions and living. So for financial guardianship, instead of financial guardianship, which you should never get, don't ever get financial guardianship. That's fine. That's just blanket advice. You don't need to either. Probably your child's sole source of income is going to be Social Security, SSI, and then after you retire, SSDAC, Social Security SSADC, dependent adult children. I can't remember. SSDAC, Social Security for dependent adult children. And then for that money, to control that money, you just need to be the representative payee. You are going to have to schedule an appointment or go to your local Social Security office get there early, get your number, and hang out with your child. And then your child basically can authorize, or if you bring your child and Social Security sees the situation, they will name you the representative payee. And that means now you control those Social Security payments. The money is going to come in and you have to track it. And once a year, you'll have to explain where the money went, which mainly it's going to go to housing, and food. It's not very hard to explain. The requirements for explaining it aren't as hard as they used to be. For Medicaid, like I said, you can become the authorized representative. So if they're entitled to food stamps or benefits like that, you can become the authorized representative with that organization. Yes. So the question is, if you get guardianship, are you automatically these things? And the answer is no. First of all, none of you should get financial guardianship. But even if you do, financial guardianship and guardianship in general is a state court issue. Social Security doesn't recognize it. They do, you have to file it with them, and then with that, they'll authorize it. And even if you're guardianship of the person, then because you're guardianship of the person, they will name you representative payee. They'll use that, but you still would have to go to Social Security. Nothing, yeah, but nothing is automatic. Nothing. And even if you're guardianship of the person, that doesn't give you power over the money. And if any of the money doesn't, if anyone complains about how you handle the money, they'll take it away from you. They could take it away. And the only people who ever complain are if your child lives in a group home and you're not paying the money you owe them. So you can become an authorized representative with Medicaid, with Job and Family Services. If there is a lot of money, and you can actually just put the money into a trust, and then as the trustee can control the money. They don't need to be guardian, financial guardian. Okay. And then if you want to be able to talk to banks and credit card companies, like if your child goes out in the world and kind of gets into a credit card company and gets a credit card or something like that, you can become their financial power of attorney. So I have a link here to proseniors.org, and they have a form for a financial power of attorney form that you can use. It's just free online. It's because your child doesn't own real estate, it's a perfectly good power of attorney, which means you can use it too, unless you own real estate, and then do not use that form. It's not really good for real estate. So if you own real estate, don't do it. But if you don't even own real estate, you can use that same financial power of attorney form. It's fine. So yes, do you have a question? So the question is, why do we never get a financial guardianship, but it's okay to do financial power of attorney? So here's the problem. If financial guardianship requires, I mean, and I say never do that, but if your child suddenly comes into $1 million, like they buy a lottery ticket and they win $1 million, we're getting a financial guardianship. But the reason you don't want to do that is because, and I probably still would say don't do it, throw it into a trust, but the reason you don't want to do that is because when the money's in financial guardianship, I have to get court approval for every expenditure. Okay. And you have to file an accounting every year to the penny, every dime that came in and every dime that came out, and it's got to match. Okay. It's fine. I do them for a lot of people. I'm financial guardian for tons of people. And because as much as I tell you don't do it, I do it all the time, but I do it for senior citizens who have money, but don't necessarily have family members, or have family members who will steal their money. And so we do it where we're just kind of protecting the money to keep them living independently as long as possible, because they can handle their own money. But it's a lot of work. It's a lot of paperwork. In Hamilton County now, the judges require that the attorney sign off on, co-sign every check. Can you imagine that? The bill for the attorney, it is not a financially viable option, really, for most people. Like as an attorney, I no longer will do it if the family member is the financial power, is the guardian. I'll be the financial guardian, but I'm like, no, because they write checks and the bank cashes them, but I'm on the hook for that. No, I won't do it. And I'll do it if I'm the guardian, but I can't be co-guardian, basically, not even, it's too much risk. So, and that's why, but a financial power of attorney is a document where you can step in and handle things as you need, as you see fit, right? You have to act in your principal's best interest, and that's your child's best interest. You can't take their money for your own benefit, but as long as you're doing that, you're probably okay. And unless somebody files an allegation of abuse, no one's really going to question it too much, right? So there isn't the day-to-day oversight. Plus, again, your child shouldn't have that much cash that they need financial guardianship, if that makes sense. You know, you need financial guardianship because there's a large sum of money that could be drained if people aren't paying attention to it. But if it's just the Social Security, it's in and out, it's out, it's in, it's out. Right? And if you have too much, you put it into a stable account. If you have way too much, you put it into a Medicaid payback trust. I mean, you shouldn't need financial guardianship unless they win the lottery and they win $1 million. And they're young. And so then we might want to take them off. Now they got $1 million. They don't need Medicaid. Let's go crazy for a while. That's okay. If you have questions, somebody else does too. It's fine. Power, yes. So you can be the guardian of the person and have a financial power of attorney. That is correct. Well, the trick there is you have to have your child sign the financial power of attorney before the guardianship is appointed. Yeah. 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 I suggest you do it before you get the doctor to sign the thing saying the child's incompetent, but yeah. Well, so financial power of attorney doesn't need, again, you can go on Pro Seniors and have it download the form. It does have to be notarized. I will say that generally an attorney is probably your safest bet to have it notarized. A bank might balk at it unless you know them. And what I do is I'm like, do you know who this is? Do you know who this woman is? Oh, it's your mother. Okay. Do you trust them to make the decisions? I have to show, they have to show to me evidence that they understand who you are and that they're giving you some power. And if they won't sign that, then I'm not going to notarize that document. If I don't believe that, if you have again, as I said, if you have a completely nonverbal child, then I'm not going to do that. But again, if you also have a completely nonverbal child, I'm not sure why you would need a financial power of attorney, because it's unlikely that that child is going to go out and get a credit card in their name. Because the financial power of attorney is to deal with third parties. Social Security has its own system. It's the representative payee. So, so I might not need a financial power of attorney. So, but yeah. So actually, that's actually an interesting fact, an interesting thing that's coming up about. So the question was, for a power of attorney, do I have to wait until the child is 18? Legally, yes, but we have seen children's hospitals start demanding it of teen boys and girls, on the grounds that if a teen girl asks for birth control, they have no obligation to tell the mother or the parents, and they don't. And so they're using the same standard for the boys. So I have now had to notarize 3 or 4 healthcare power of attorneys for 12-year-olds and 13-year-olds. Now, to me, do I think that's a legally binding contract? It's not, but the hospitals are requiring it. The child does understand what they're doing, but I think it's a piece of junk. I mean, I just, I don't think it has any, but again, they're requiring it. So on the same, on this, they require it for girls, so now they're requiring it for boys too. So, hey, listen, whatever. I don't think it has any, I don't think it's valid, but okay. I mean, I am notarizing his signature, the child's signature. Okay, that's what I did. They're not capable of entering into a contract. So, and again, the parents are natural guardians, but because of the whole birth control issue, that's why that's coming out. So, you can have, if your child is working, you can have them do a direct deposit, then they don't have to sign the back of a check and the check doesn't go missing. You can have a joint account. Now, just to be clear, the Social Security money has to go into a representative payee account. But other money you can, and you're going to be on that. If you're the representative payee, you're going to be on that account. You have control of it. So, but if you wanted to, your child could be having their money direct deposited into their account, and it can be a joint account with you. I strongly discourage you putting your child's name and having them put their money into your bank account. Because you have commingled this, and if their social security number is attached to your bank account, this could drastically make any benefits for them much more difficult to obtain or keep. Does that make sense? It's fine if, don't have your paycheck going in the same account that your child's paycheck is going into. Don't have your paycheck going into the same account that your child's social security's payment is going into. Keep their accounts separate. You can be on them, but your money shouldn't be in them. Yes.
Our rep payee, that's just the option we chose versus guardianship.
Mm-hmm.
That account would have me and my child on there. It's under both of our socials.
So the question is, if I'm the rep payee for an account, it would have both names on it and who's social. It should have your child's social but in your name on there. I actually don't know if your social's on that. But the bank has your social, but I don't think it's attached to you.
The child would still be the primary.
They don't have rights to take the money out. You can limit their rights. You control the account as representative payee, not them. So what rights they have is up to you as the representative payee.
Some like you get a mortgage or whatever, and you have to disclose what accounts you have. Is that considered?
It's not your money. So the question was, and sometimes when you apply for things, you have to disclose the accounts you have. It is not your money. It's like I'm guardian of people who have a lot more money than I do, quite honestly. It's not, my name is on it, my social security number is attached to it but it's not my money. I can't use that money I would go to jail if I use that money for my personal use. Yeah. So yes. You can set, so the question is, can you set those accounts up joints with rights of survivorship? Yes, you could. Not the representative payee account, but the other ones. Yes. Yes. Yeah. Because I recommend all bank accounts to have rights of survivorship. But if you're the representative payee, even if your child were to pass away, you have control of that account for representative payee accounts. But you're right, joint accounts would be different. So, but yeah, and then as you age, you might want to add a younger person onto that account. You can also make direct payments to service providers. So you can set things up if your child's money is going into their own account. You can set it up that the bank is automatically paying service providers, so you don't need to get them to sign checks and things like that. But you're going to have to have a lot of oversight on something like that. If you run the money through Stable, that's another way you can do that. So these are all alternatives to guardianship, right? You can control bank accounts in a way that you don't need financial guardianship. You never need financial guardianship. Now, for the regular personal guardianship, like to make healthcare decisions, the decisions of where they live, again, there are alternatives. We already talked about one, which is the healthcare power of attorney. Same thing. You can go to Pro Seniors for a form of it, or you can go to hospiceofcincinnati.org. They have healthcare power of attorneys. They also have living wills and DNRs. Do not have your child sign a DNR. That's just, they don't need to sign that. That's something you do with a doctor. And living wills, that's if they've signed the healthcare power of attorney, you have the ability to make those decisions anyway. So, and that's just a form you fill out. You can contact Adult Protective Services if they're in a dangerous situation. If there's somebody in their life that is leading them astray, that is leading them into inappropriate behavior, you can contact Adult Protective Services. Your child's an adult, and they're a disabled adult who needs oversight. So APS, and APS is a form of the police. You have to be careful with that with mental health issues, but if you have someone who's a bad influence, that can be a way of separating them from them. You can also get a protection order, the same thing, right? Now for a protection order, you have to show that there's been some violence. You have to be able to testify that there's been a threat or a menace of some sort. And another big alternative to guardianship is having a large circle of support. And obviously that's not always within your control, but the larger the circle is, the people who are willing to step up and do things and be part of that is an aspect of it. So we don't talk a lot about it, but conservatorship, everyone kind of knows about it now thanks to Britney Spears. So it's like guardianship light. I don't really see it around here. You can have a support broker. There are all these, the chosen representative is the form with the county DD boards. You can have them sign releases of information. So let's say your child did open a credit card account someplace and you didn't have financial power of attorney, there'll be a release of information where they can sign saying that you can talk to them. And again, when I say sign, they just have to be able to make an X. They don't have to actually sign their name. But these are alternatives to guardianship, to that one. So I'm going to talk now about the types of guardianship. So a limited guardianship is just that. It's for a very limited purpose. One of the times that I see this, it is the least restrictive form of guardianship. It doesn't last very long. Oftentimes what happens, we see these is like a child inherits some money from some relative who doesn't realize this is going to mess up their benefits. And so we get a limited guardianship for the sole purpose of placing the money into a stable account or a special needs trust. Because that child can't do it. The adult can't do that. And so we get the court, and the courts around here, we file those all the time. Okay, they just sign off. They don't care. Okay. So even if you're the guardian of the person and suddenly they come into a lot of money, you don't need to become their financial guardian, because you can, for a limited guardianship, to just put the money into a trust and then avoid all this oversight and the constant filing and the records and requesting money. I need to spend money on this. I have to get court approval for that. For the record, just to be clear, when you get court approval for that, you actually are just, you can basically send the court a request, and you can spend, I don't know, $500 a month on medical bills, $300 on clothes. You can spend a lot of money each month before you have to go back and ask for extra money, if that makes sense. You can have blanket approval. You don't have to ask for every penny, but you have to have generic approval for things. And then at the end of the year, you have to show, hey, I spent $200 on clothes, and that's okay because of this order, blah, blah, blah. So guardianship of the estate is when I'm handling your money. Guardianship of the person is when I'm handling where you're living. And plenary or full guardianship is guardianship of both the person and the estate. Again, for individuals with developmental disabilities, you really should only be looking at guardianship of the person. It would be exceedingly rare and unnecessary to get guardianship of the estate. That is something, plenary or full guardianship and guardianship of the estate is something we see with senior citizens who have a lot of money, who have severe dementia. That's when that comes in, right? For people who are developmentally disabled, they don't have the money to need the guardianship of the estate. I already talked about emergency guardianship, that situation where you go, it's actually gotten really weird in Ohio. There's a whole new rule for it. I'm sorry, that's not true. Wait, scratch that. It's gotten really weird in Kentucky. I'm licensed in 3 states. Sometimes I forget stuff. In Ohio, it's totally normal to get emergency guardianship, but it doesn't last very long. It just lasts for a few days. So it's usually, nobody really does it anymore because it's just a short time. Interim guardianship is, again, something, it's another form of limited guardianship. I just need it for this little thing, and then I'm going to walk away and not be guardian anymore. A guardian ad litem is where the court appoints somebody to represent the child, the individual with the disability. That's where there's some proceeding, like a probate case, and there is no guardianship in place. And so the court will name an attorney. It's almost always an attorney. They'll name an attorney to act on the wards and to act on behalf of the individual with the disability who does not have a guardianship in place. And then that person will file things on their behalf and then make sure the money gets transferred properly. And they're going to report everything to the court because they're going to answer the court. And what was asked about earlier, co-guardianship is very common. We mainly see it between spouses. But as the courts have become more liberal about that, as I have a lot more clients who are aging, I'm seeing one of their typical kids being named a co-guardian. And then once neither parent is able to handle it anymore, or doesn't want to handle it anymore, I'm seeing siblings being co-guardian. And around here, they've been very laid back about that. And it's good because it makes sure that if something happens, there's always somebody else in place, and it alleviates a lot of the burden, right? You can go on vacation because, you don't have to rush back. Now, when you go on vacation as the guardian, you cannot just name somebody else guardian. You don't have the ability to do that. You see that happen every once in a while. And some places will go, okay, sure, that's not legal. You can't do that. You don't have the right to do that. Remember, you're the guardian thanks to the court. You don't then have the power to name somebody else guardian in your place. That doesn't work that way. I actually had a case like that where the guardian went to prison and named his girlfriend the new guardian. Well, what? You know, who is this person? She's not even related by blood to the ward, like, and they're all these siblings. I'm sorry, what the heck is going on? And so the court had to kind of step in and be like, let's stop all this. All right, now before 2008, the guardian of an adult had to be a resident of Ohio, which was really annoying. Now you can nominate, if you have a child with a disability, you can nominate somebody from another state. And you can do that. I strongly suggest that you can do it in a power of attorney and in your will. So if you have a lot of people that would do it, you have a huge family and circle of friends who would act as your child's guardian, I suggest you do a limited power of attorney and just list them all. List everybody you'd ever want to be their guardian. Because in Warren, Butler, Hamilton, and Claremont County, people move across the borders pretty easily, right? It's not that hard to end up in Indiana. Oh, Hidden Valley's nice. I'll retire there. Ah, crap. I'm not a resident of Ohio anymore. Or, oh, I'm going to go live in Covington. I love the street, you know, especially the kids, they move to Covington. And because it's fun, Newport and woo. And then suddenly they can't be guardian anymore. So this is a way of doing that. Now, I will say in Ohio, as of 2010, probate courts regularly appoint people to will name out-of-state guardians. But I still strongly recommend you have that form, have a piece of paper that you can use that same power of attorney that I talked about online, but you just say for that all of these people can be the child's guardian if there is one needed. So you just and then you have it notarized, and that way that document's floating around. So if your typical child moves to Tennessee, but they should be the guardian, they want to be the guardian, they get to go, hey, wait a second, my mom said I should be the guardian. I'm next in line. Doesn't matter that I live in Tennessee. Yeah, I know these people live in Ohio, but I'm their sibling and I'm involved. And that's going to give them a leg up. So, and again, all you're doing is nominating somebody. They have to apply to actually become the guardian, and the court has to approve it. I occasionally see attorneys who don't do this for a living. I'll see them like name the typical kid in charge of all the money, and I'm like, they're 12. You have no idea what they're going to be. That is a horrifying thought. I mean, they're 12. I once saw one of the big firms downtown put a 17-year-old who was the sweetest thing in the world, but I'm sure if I wanted to, I could manipulate anything out of that kid. They put her in charge of a $13 million trust. And I was like, what in the world are you thinking? $13 million. She was turning 18. If I wanted to, I could convince that kid to do anything. Anybody could, because she was just the sweetest thing in the world. She should not be in charge of a $13 million trust. And the reality of it is that, you know, okay, that was horrifying advice, but anyway, they did it. Here, if you name it your typical kid to be the trustee, but when they go to apply, they have now a series of bankruptcies, they have some domestic violence arrests or drug, they're not going to get to be guardian. That's not going to happen because they have to submit to a background check. And so even though you named them, the court is probably going to say, no, for the safety of the person, we're not going to do that. So it's not a sure thing. So the other thing I get is, well, if I'm the guardian, am I responsible if the ward does something wrong? What if they can't pay their bills? You're acting, this is really important. If you're the guardian and you go anywhere and take them to the hospital and sign them in, you should not be signing as yourself. You should be signing their name, guardian, or your name, guardian, right? You are not responsible for that bill unless they have money to pay for it. And then you're supposed to use their money to pay for it. You are not responsible for paying that bill. And that's something you should understand. You're also not responsible if they were to do something criminal. You're not responsible for that. You can't be responsible for that. The only time I've ever seen anything like that is, and I question the validity of it, when a court orders you to place somebody in a restrictive environment because they're basically being told to place them in a lockdown facility and because they're committing violence, and you don't. But you wouldn't be going to jail because of the criminal act they committed. You'd be going to jail because you were in contempt of court. Right? That's what happens there. But you're not responsible for their criminal acts, and you're not responsible for their debt. So, but you always want to make sure that that you've made clear if you're signing things, if you're entering, that you're doing it as the guardian. Now, in the DD system, and if you cannot be the provider and the guardian unless you're related by blood. So if you have them living in a LAD house, LAD cannot be the guardian. It's not going to happen. It would be it's a big no-no. And that's obvious. There's reasons for that, right? Because the guardian should say, oh, this isn't, I mean, it's, LAD's fine, but if something happens and LAD's not fine, okay, well then we should move them. But LAD wouldn't agree to do that. This is why I need to make him fake name because I'm not trying to say this about provider A. If you name provider A as the guardian, then provider A goes downhill and they should move them to another facility, but they're not going to because they need the money from the ward, right? That's why they cannot be the guardian. So you have to always be able to advocate for them, and that includes moving them to a different facility. In theory, you should obviously talk to somebody who you're nominating to be a guardian. If you're going to list all your family members and friends, sure, okay, or you can list them. Who cares? You can figure it out later. It's again, just because you nominate them doesn't mean they have to do it. They have to apply, but you might want to talk to them about what it means to be guardian if you think that's the route you're going to go. Because if so, they need to understand it. It's not as much work to be guardian of the person. Isn't as much work as you would think. Currently, the expectation is that you see the ward about 4 times a year, and that can be through Zoom meetings. But they want to know that you're reaching out to them and seeing them. You have to file a report with the county, either each year or every other year. It depends on the county, where they live, when's the last time they saw the doctor, what are the goals, what are the plans. You have to know what's going on in their life. And then you do have to get a statement from the doctor saying there's a continued need for the guardianship. They still have the disability they had before. If there is nobody to step up to be the guardian, there's something called APSI, which is a nonprofit agency that handles guardianship throughout the state of Ohio. They have a massive backlog. So they're only going to step in and be the guardian when there's a dire need, because they have thousands of people waiting to be guardians. We are seeing in Franklin County, which I think is the coolest thing in the world, and I hope to see that coming down here soon. In Franklin County, they now fund a guardianship organization where they're professional guardianships who are paid by the state. It's like DODD, only it's the Franklin County Guardianship Office. And so these people will act as guardians for anyone who needs it, and the state pays their fees. And it's funded by the county commissioners and all that stuff. And it's great. They're handling all the guards. So there's nobody in Franklin County who's going without a guardian. That's like the first county that's doing that. Now they're starting to expand it right around there. Like I think they're going into Delaware, and I don't know enough counties up there. That's all I got. I got Delaware and Franklin. That's all I got. And so I don't know. Fairfield is south. That's not right. But they're starting to do that. And the goal is to eventually get this throughout the state of Ohio. And that'll change things. But for the record, that's going to be 25 years down the road. I mean, we don't move very fast. And of course, each county has to pay for this. And it's all it's overwhelmingly attorneys in these offices. So it's not cheap, but we're seeing that. But so right now, but APSI is volunteers. It's a nonprofit, and then they have volunteers. But and that's another reason why when I say, like, be careful about getting guardianship, because once you have gotten guardianship, you kind of have to keep guardianships in place. And so if you don't have the next generation thought out, your kid can end up in limbo later on. So if you want to get guardianship, you do not need to hire an attorney. unless you're in Gallia County. If you're on this website and you're in Gallia County for reasons that I cannot understand, explain, or substantiate, the judge there requires you have an attorney. It's called welfare for attorneys, but the rest of the state, you don't have to have an attorney. And quite honestly, you really don't need one. It's just you got to do the paperwork right. And some people get stressed out by that. And so, you know, then that's why you hire an attorney. But everything you need, including the statement of expert evaluation, is there in all the forms. If you file the wrong forms, they'll tell you. They'll say, they won't tell you until after you file them, but then they'll tell you. They can't give you legal advice. But there are booklets on how to do it. Many of the counties have booklets on how to do it. You don't actually have to have an attorney to help you do it. You don't. It's not necessary. You shouldn't be charged a lot of money. Someone told me it's thousands. I told someone they needed guardianship. Now that was for their spouse who has dementia. She said, I don't have that kind of money to do that. It's going to cost like $10,000. I'm like, what are you talking about? It's not going to. What? No, it's not. Around here, you're looking at $1,500 to $2,000 for guardianship. Yes.
Would want to be careful to, if he doesn't have a job or doesn't have a as he's just turning, what she was advised to do, she did was file an indigent, and that way he did not have to pay. No one had to pay for it.
Yeah. Yes, you can do that. In many counties, you can actually file a request to do that they're indigent, and then there's no fee. That's paid for by the state, and there's no fee. So, yeah, it's a handy dandy little thing. I mean, the filing fee is like $200. It's not the end of the world. The only downside to that, and it's not that big of a downside. So usually when I get involved in those cases, it's because suddenly they came into some money, and now I got to pay back all those fees. Anyway, so, but you're right, but yes, yeah. And if you have an attorney, they're not gonna, then yeah, they're gonna make you pay. We always have you pay the court costs, because I just figure, like, yeah, if you can afford to pay me, you can afford to pay the $200 court cost. I'm not gonna, me filing the motion for indigent is more expensive, but it's for you guys, it's just a form you fill out. But you really don't have to have an attorney to do this. The filing fee, the court cost depends on the county, but figure out $200, $250 max. It does depend on each county, so I don't check that often all that much. Like I said, the court investigator is going to come out to your house. Now, if your child is in school or in a shelter house situation during the day, when you file that, you should just put a piece of paper in there. Here is where they are during the hours of the day. Right? They're not here at this house. So if you come to the house, no one's going to be here. Here's where to go. They love that. It makes life so much easier, because the number of times we have to continue a hearing because they didn't know that was annoying in the beginning when I first started doing this stuff. Like I said, there's this hearing. It's very informal usually, and it's almost always before a magistrate. The only time it's going to be in front of a judge is in really small counties like Greene County. Even Warren County, it's going to be a magistrate. And the magistrate, like I said, generally just asks questions. They will tell you if they expect your child to appear. And if they don't, you don't have to bring them. You can, but you don't have to. Once the hearing takes place, they'll tell you that day whether or not they're going to grant the guardianship. And then usually they'll sign the paperwork, and you get the letters of authority, letters of guardianship, saying that you are guardianship of the person. They'll give you as many certified copies as you want that day. You can always go get more anytime you want, but honestly, nobody needs them. A copy is as good as the certified stamp. Almost no one needs that. I always tell people, once you get that, scan it, save it somewhere on your phone where you can access it. Right? Oh, here it is. And then you can email it to somebody that had to have it right away. Because if you're in a hospital situation or something like that, that's it. That's your badge. Keep one in your wallet, keep one in the car glove compartment, so you have access to it really easily and quickly if you do it. So, but that's the badge, and that thing stays in effect until the court revokes it. And they won't, unless you do something pretty bad, they're not going to revoke it. So now, once you're the guardian, you have responsibilities. So you always have to act in the best interest of the ward. And I think sometimes parents don't understand that, but you do. I know what you want, but if they want something different and what they want isn't bad, then you're supposed to do what they want. So, you're supposed to take them into consideration. And if you're not, they can go to the court and say, hey, I want stuff and they're ignoring me. and then the court could remove you. They won't, but they could. You have to file this annual or biannual report, like I said. And you have to seek required training. Okay, so not around here, almost no one requires it, but I still say if you are even thinking about becoming a guardian, they're free online trainings. And there are 3 hour ones and 6 hour training sessions. I wouldn't take it I wouldn't do the whole 6 hours this too early, because some counties require it, and then it would be really old. But I strongly suggest you watch, even if the county doesn't require you do the training session, I strongly suggest you do it. It's free, and it's going to answer 1,000 questions for you that you're going to have for your attorney. And it kind of gets you, and it talks a lot about guardianship of the estate, but it does talk quite a bit about guardianship of the person too. If you listen to it, you're going to understand why I say do not become guardian of the estate. Never do that. And in the counties that require it, Butler County, by the way, is one that requires it. You also have to do the 3 hour refresher courses every year. I have to do those because I'm a professional guardian, because I'm an attorney. And so every year I have to find one and watch. It's 3 hours. But it's, I just sit there in my house and watch 20 minutes at a time and come back, watch another 20 minutes and answer silly questions. But it's really, now, by the way, this PowerPoint presentation will be on the SALT website, Facebook page, so you can access the link to this. But basically it is the Supreme, if you type in Ohio Supreme Court guardianship training, you're going to find this. You'll have to create an account. It's free. You just, log in, and then that way it'll track your training. So most counties are very lax in enforcing the family training, but I think it's silly because the purpose behind it was specifically for families. Now, these are the counties that had in-person training. You don't have to live in Butler County to go to the Butler County one. Obviously, this predates COVID. None of them have come back yet. We're not sure if they're going to. But Butler County did. I did mine in person in Butler County. So that's, it was nice. You had a little break for lunch. It's nice. All right. The other thing that you have to do as a guardian, you have to see them often. Now, that's also one of the rules. You actually have to see them, but they're not, especially even before COVID, you could do that electronically. You have to ask their opinion, and you always have to advocate for them. So that is one of the responsibilities that you do have as a guardian, is to try and get the most available for them in benefits and things like that. That's part of your job as the guardian, is to provide for them and give them whatever they need for those things. I already mentioned this. You can't delegate the power of attorney. You could do a consent to treat, but you could also, if you're going to leave the country for a period of time, we suggest you notify the court, and then the court knows that they're now stepping up. And because in part, because if we really do have some emergency thing, the court's already aware you're out of the country, and then they're going to let me fly by with whatever I need to, if I need someone else to step in for a while. So as a guardian of the person, you can open a stable account. And if you want to open a trust, you're going to need to get that extra guard. You're going to need to get the court approval to do that. So stable accounts, you guys know what stable accounts, right? The bank, they let you sit there and say, hey, I'm guardian, I can open a stable account. But trusts are going to require an actual court order allowing you to do it. But you don't have to become guardian of the estate. You can get that interim or temporary order saying, hey, I just need it for this one thing. And then you submit that, you can open a trust. Trusts are another conversation. Anyway, when we're talking about what are the best interests of the ward, the idea is that you would, obviously people are going to disagree, but if you were the ward, what would you want, right? What would a reasonable person want in that situation? And the ideal world is that you're going to follow whatever they would like, whatever the ward wants, unless it's going to cause them harm or it violates some existing court order. But your main goal is to keep the ward safe, nourished, and healthy. So this is my one true story about this is I had somebody call that in Claremont County, they'd shut down the shelter house, and the kid didn't have any place to go during the day, and the mom worked. And so they were like, she's leaving. He would have started the house on fire if he was in the house alone. So she locked him out of the house when she left in the day, and she had him in the garage. There was no car or anything. And I know, yeah, and she had him in the garage with a TV and like food and water for the day. And they were like, can she do that? And I was like, is she the guardian? And they said no. And I said, yep, she can do that. She has no legal obligation to provide housing for her adult child. If she were the guardian, no, God, no, she could not do that, right? That is not the safest situation. If a guardian's not doing a good job, you can file something with the probate court and let them get involved. They might have an investigator go back out, and they could have a hearing. For that, you're going to generally need to have an actual motion. But I will say this, if the guardian is a family member, it's almost impossible to remove them. The county can't really do much as relates to guardianship because since 2010, they can't be involved, but they can notify the court if there's some behavior that's inappropriate, right? Like the person locking them in a garage all day. But since there was no guardianship, there's nobody really. Now you could call it all protective services. And even though there's a guardianship, the county does have to arrange anything they need. All right, so terminating the guardianship, it's very, like I said, it is very hard to do. Instead, what we suggest, if you want to end it, that you try and go to a less restrictive form of guardianship, so some sort of conservatorship or something like that. And then once a year, the ward has the right to ask to end it. And if they do, if the ward files a motion to ask to end the guardianship, the guardian has to prove that there's a reason to keep it in place. Historically, you couldn't get married if there was a guardianship in place, but some of the courts around here, people have gone out and gotten married and they said, okay, that's it, guardianship's over. So, which is really weird, but marriage is a fundamental right. And so the courts can't take away your fundamental rights. I mentioned this earlier. For DD, for the county DD boards, you can have this form called the chosen representative. You can have that person. There's a form you can fill out. It has to be in writing. And then they can help them make decisions with the board. It can't be a provider. It can't be somebody who has a financial interest in the decision, right? It has to be a non-interested party who's the chosen representative. Again, like I said, we're going to always presume the person is competent until a guardian has been appointed. That's an important concept to make. And it's something that you need to push back on if someone says your child's not competent. Prove it. Only the court can deem somebody incompetent. A doctor might say, I don't believe they understand the decision. Okay, but they're competent until the court says not. Right? I mean, that's the end of that. But you can push back on that, quite honestly. So you have the right to ask for a family member to help you make decisions. There's nothing wrong with that, even if there's not a guardianship in place, and it's a good explanation of why you don't have to have a guardianship in place. Sorry. And even if you have a developmental disability, it's clear that you still have the right to participate in any decision that affects your life, whether there's a guardianship in place or not. But you do have that right to be involved in the decision-making process. So when there's an alternate decision maker, like a chosen representative or guardian, they always have to, that concept of best interest of the ward is paramount. And that's going to be grounds to have you removed if you're making a decision that is not in the ward's best interest. So if you're not, in all of the, as guardian or in any other capacity, you have to take their lifestyle and their preferences into consideration and use their values and beliefs as the guides to making their decisions, and make those decisions that they would make if they were capable of them. And again, that goes back to, I understand that sometimes parents want to protect their children, but if your child has an interest that just is against yours, it doesn't mean they don't have the right to follow through with that. So, unless it's going to place them in an unsafe situation. So, but always look at the alternatives before you do that, and looking for more supportive environments. We're seeing this, we're seeing more and more providers and healthcare providers understand that guardianship isn't the only route. And that's great, because we don't want to be forced into this. So helping the individual make good decisions is the best way to limit the need for guardianship or limit the need for the guardian to act, even if you had to go that route. So Disability Rights Ohio has a book about guardianship from the individual's point of view. They also have a lot of supportive decision-making training videos. The probate courts have the training that we already mentioned. And the advanced directives, as I mentioned, you can find them on the hospice or also Midwest Care Alliance. And there's a guardianship guide from the Ohio Attorney General and the DODD. They have a book about guardianship also. These are all resources that you should use, that you can use to help make decisions going forward about this. All right, Patty, do we have questions from the chat?
There is no questions as of right now. I'm just sending a message out asking them if there's any questions. They can type them in the chat box, those who are here virtually. I'll close the recording here in just a minute, and we can also do a verbal, let them ask verbally too. Oh, thank you. For Laura or Michelle put your contact information here in the chat box as well.
Okay. So we have a question here.
So just in summary, so in order to get like steps to guardianship, doing that, go to probate, that information.
Yes, if you want to do guardianship on your own, I would start at the probate court's website. And I will say this, sometimes the county you live in might not be the best resource for that. You might want to look at like a larger county like Hamilton or Franklin, who might have a more clear and concise guide. Generally, the forms are going to be the same. Each court has their forms online. And so you can, I mean, honestly, I do that. Like I have something weird that comes up, and you know, Greene County Court had a whole explanation of how to do that. And I'm like, oh, look, now we took those forms and we made them for Hamilton County, because Hamilton County, there's nothing about it on Hamilton County's website. So you can, it was something weird. That is actually a true story. I don't remember what it was. Oh, it was transferring a guardianship from out of state, which happens a lot. And that's true. Once you have guardianship here, if you move to another state, most states have something called the Guardianship Act. It's a model code thing. And so you can usually transfer your guardianship to another state pretty easily. And even within counties, you can do that also. Yes. Oh.
So you do that or whatever. What comes first, the chicken or the egg? Do that and then file for Social Security?
So the question is, do you file for guardianship or Social Security? You can do them at the same time. They're not related. So I will say this, yeah, if your child's disability is iffy, guardianship may help you get Social Security, but it doesn't matter because you can always start over if that's really a big problem. So to me, once they turn 18, you file for Social Security, and if you decide guardianship, you can do them at the same time. They're not exclusive. They both, so generally when you file for Social Security, they're going to deny you the first time. So it's going to take a long time. So you want to start as soon as possible, because the retroactive, it goes back to the day you filed. So you, huh? Yeah, you can, as soon as a child turns 18, you can file for Social Security, SSI for them. Yeah. I'm sure it is. I do not do SSI. I don't do that anymore. I did in the past, but I've walked away from that because you know what? You can get into too many things. So, and you had another question here? So the question is, are there places in the country that are better for disabled adults than others? Absolutely. Overwhelmingly, Ohio has some of the best benefits. When my aunt was growing up, Iowa had the best benefits. I don't believe that's true anymore about Iowa, but she was grandfathered in. She had amazing benefits. She had a nice, and we wanted to move her with us when we moved to Ohio, but I talked to people here. My parents finally moved to Ohio, and because we were all here, and they wanted to move my aunt, and it wasn't realistic because of her age. They just would have placed in Ohio. They would have placed her into a nursing home. So yes, there are states that have good benefits and that don't. Ohio has, it's my understanding that Ohio has some of the best benefits in the country, but I'm not an expert in that, but I do know like Mississippi has horrible benefits. I know that. So yeah. Yes, you have another question?
People like Ireland, they have no resources. From line and choose and the quality of life. Quality of options associated with doesn't mean thought.
So the question is like we talk about, you know, if you have a lot of money and you're and you're older, you can choose which facility to live in, and versus if you don't, you would have to take a Medicaid bed and a nursing home. So just to be clear, in Hamilton County, Warren and Butler, I believe there's only one facility that doesn't take Medicaid. They are all Medicaid beds. Now, assisted living is different than nursing care, just for the, I'm not going to get into that because that is complicated, but but yeah, I mean, you couldn't pay me to go into a nursing home in Florida. I don't trust them. There's too many seniors, there's too many nursing, I can't, and also they don't seem to have good regulations, so I wouldn't live there. But it doesn't mean that being in Ohio, which I think does have a lot of good systems, is going to protect you in a facility that isn't taking good care of people. I mean, there are a lot of factors that go into that. I will say that the advantage in Ohio is that the county DD boards seem to me to be involved in their clients' lives. And even if you're not here anymore, they have systems in place to go and check on these people who are living in their group homes, and they have systems in place that hopefully will protect the majority of the wards and the majority of the people with disabilities. You're always going to have problems. You're always going to have things that individuals who slip through the cracks and bad things happen. There's no way to prevent that 100%. My understanding is Ohio is a really good state. Like I know Indiana's not. I know Kentucky's iffy. I know Mississippi's bad. You know, I know I wouldn't move to Florida, but it's one of those things you have to really investigate. And the thing that I would say is that Ohio has the IA waiver, which is one of the most generous ones, I believe, in the country, but they also have really detailed, and they have great organizations like Ohio Disability Rights who make an effort to protect and represent and advocate for individuals with disabilities. And I think that's what makes Ohio so great and such a good opportunity. I think for a while there, when Kasich was governor in his first term and he decided to overhaul the DD system, there was a real fear that it was going to completely and totally deteriorate and become a problem. And even he was like, oh yeah, we got to put more money in that. So I think that's one of the things I like about the state is I think we have done a very good job of supporting our individuals with disabilities, which to me is the hallmark of whether or not I mean, if you're not going to support individuals with disabilities, what the heck is the point of the state? I mean, to me, that's what they should be doing more than almost anything else. Provide K through 12 education and individuals with disabilities. Everybody else, figure it out. So I do think Ohio's great for that, but there are other good states, I'm sure. I do know, and I bet your Warren County people could talk about the fact that because Wright Pat many people are here in Warren County and Montgomery County because of Wright Pat and because of the Air Force, and then they leave this area and go to other states, but they demand that Ohio be their center for basis for where their child is listed as disabled, and they get the benefits from Warren County, even though they live in Colorado or California and other states like that. Because, and I know it's true in Montgomery County too. Is that still an issue? I know that used to be a real big thing up here. Oh, okay, yeah. So it's a big thing up in Montgomery because as a military, you say, well, my home base is there. So it's probably bigger in Montgomery than here. But I know back in the day, there were a few families like that. So, you know, so, but obviously there are lots of states that have great benefits too. But it's what you need to recognize is that if you move out of state after your adult child reaches a certain age, the benefits that they might get in their new state are going to be altered based on where they are in the system, right? They're not coming in as a child. So any kind of move like that needs to be taken into consideration. And we see that, you know, I have a client who she's retired and she doesn't want to stay here anymore, you know, all the time. And she doesn't. But her child can't leave the state of Ohio because of the benefits that he receives. And so, you know, she leaves a lot now. She's kept a place here, so a condo, so she can come back and see him whenever she needs to. But he gets better benefits here, and his siblings are all here. So they're people they're people actively involved in his life. But it made no sense for her to take him where she was going because he wouldn't get the benefits he does. So do we have any questions, Patty, or no?
No, but if you have a power of attorney, say if you create one and you live in one state, like say if you live in Ohio and you create a power of attorney and you move to Kentucky or Indiana, do you have to recreate that power of attorney, or is it good in a power of attorney form?
The healthcare power of attorney should be good in any state.
Okay.
Because hospitals are pretty much, they want to just rely on anything. The financial power of attorney, what we see is like Florida has a 25-page financial power of attorney. Nobody does those because they're insane. Only people in Florida do those. What I like in Ohio, you don't need witnesses for a financial power of attorney. You just need a notary. But I know because the client moved there, in South Carolina, you need 2 witnesses and a notary. So in my office, we added 2 witnesses to all of our powers of attorney. And there's some language some states like, and so we started to slip that in. But honestly, if you move to another state, your financial power of attorney probably is going to be the problem. The other issue that happens with financial powers of attorney is banks, which shouldn't be an issue in this situation because you can just open the joint bank account. You can just open the representative payee account. Banks are now balking at really old financial powers of attorney. They're like, that's too old. We think it might have, we don't know if it's any good anymore. We want a more recent one. So that is a bit of an issue, but I don't see that in the disability world that much.
But the medical power of attorney holds up pretty well from state to state then.
Yeah. The hospitals, the doctors, they just want anything to be able to say, not my fault. Look, they have this form and it looks good enough to me. So yes, we have a question here. Yes.
My first question is, if we do the rep PE versus guardianship, we can still do a stable account. We don't have to be guardian.
So if you do representative payee instead of the stable, instead of guardianship, can you open a stable account? So if you go to stableaccount.com with your adult child sitting next to you, or your actually just set it while your kid's a minor and then it's fine. Because then you're the natural guardian. But if they're over the 18, just have them with you when you're filling out the form and then you're also okay. So
Second question is, as it relates to if something happens to my husband and I, we have guardianship, we can nominate. So if I nominated my brother, who's actually in Tennessee, to be guardian if something happens to us, they would have to file in our probate court to become his guardian. If they were appointed guardian, would they be allowed to move him to Tennessee where they are?
So probably. So here's the question. So if the husband and wife are co-guardians and they both passed away and they've nominated a sibling or of their sibling or just anyone who lives out of state, now could that out of state guardian, once they come here in Ohio, they file the paperwork, they become the guardian and they want to move them out of state, are they allowed to do that? And the short answer is yeah, pretty much. Somebody hopefully would explain they might not want to do that because of some benefit issues, but they have to notify the court of it. And if they're moving them into a more restrictive environment, they have to do something. Whenever I have moved people out of state, I've talked to the judge about it. But technically you would have, and the other state would have to accept the guardianship.
So if we nominated my brother out of state and then one of our other adult children, can they be, even though they're out of state, could the judge appoint co-guardians that are not in the same state?
Yeah, so the judge can appoint co-guardians that are not in the same state. They don't care. That was the question. Yeah. Yeah.
If the war, how quickly does this come?
So if the ward contests the guardianship,
If they haven't put it in, both guardians and one of the cases. So where does it happen? Someone has to go apply.
So if there is a guardianship in place and the guardian dies or co-guardians die, and now somebody new applies to be guardian, can the ward contest it? They always have the right once a year to contest it. So this could be their chance to do that. And then it would be up to the judge. I will generally say if the ward can go to the trouble to file the motion and explain why they shouldn't have guardianship, they probably don't need a guardian. It's usually my theory about that. It's kind of been my experience with the judges thing too. Is like, they're just, why do we have a guardian here? I don't see it very often, but yeah, in theory, they can contest it. Instead, what I would see is like, so let's say that mom and dad nominate their brother to be the guardian, and then the typical sibling says, wait, I want to be guardian. Then that would become a contested guardianship. And then what I would say is that the siblings, now, you know, they want to move your child to Tennessee. Now the siblings they can fight. They can say, no, this is crazy. We're closer to them in age and time. And also they get all these benefits in Ohio. What are you doing? And then the state there would be hearing. So then it would turn into a fight. Now that becomes a very expensive guardianship case. When people start fighting, then you're looking at thousands of dollars in legal fees. But for the record, it seems that only happens when both of you have died. So I wouldn't worry about it. It's not your money. So, you know. But yeah, that's the only time we really see contested. We see contested guardianships because two people want to be guardian, or because they believe that the guardian is being too controlling over the ward. That's, you know, or the ward says, I don't need a guardianship, and they fight it. So, but I will tell you, like, I mean, personally, if the ward says that, I'm not doing this. No, because it's too expensive for you. It's not worth it. Actually, I don't know I only know a couple attorneys now who will do contested guardianships. None of us like them, because if they can contest it, why are we doing this? So I have never seen more than two. The question is, are only allowed to be two co-guardians. I have never seen more than two. I think it would be unwieldy. I don't think the court would allow it. So, and what I do see is like mom and dad are co-guardians. Dad's getting older. Dad resigns. Another typical kid joins mom. Then mom resigns. Then another typical kid, another sibling joins. But I never see three at the same time. I've never seen that. I can't imagine the court agreeing to that. Because already it's too much of a potential of a fights if you have unrelated guardians, you know, and the court does not want to get involved in that. They don't want to be making those kinds of decisions.
Have you ever had someone ask you how far ahead they have to think? Like, so if I talk to our other grown children and say, you know, we want to nominate you if something happens to us, take care of your brother. It's like, oh yeah, sure. So some accident, tragic happens, and we both perish, and now it's on him to go apply. When I'm having this conversation with him in the beginning, should I say, oh, and by the way, if that ever does happen, you really should have a will now in case you die, and then he needs to have, you know, this knowledge of, you know, in his will if something happens to him. I'm just.
Well, so the question is like, how far ahead do you go? How many steps ahead? And so if you name in your will or your financial power, and you do a limited power attorney saying, here's who I want to be guardian if both mom and dad die, that person can't update their will to say who should be the next, because they're not the parent. So it doesn't really matter. It's your will. You should list more than just the one sibling. As far as when do you talk to the sibling about it? I mean, I think you talk to them as soon as you can. You need to have an idea of what it is that they're getting. They need to understand what they're getting into. If you're the guardian, you need to show them what the report is and say, look, it's not that big of a deal, but you're their advocate. That's the big thing. It isn't that big of a deal to be guardian of the person, but hey, I want you involved because you're their closest relative. And, but I think you need to I think the siblings need to understand what the expectations are, and you need to give them an opportunity to say no.
Is there say we die, he's got an appointed guardianship. Is there an expectation that it is in his will?
So the, if,
I'm sorry.
no, no.
There's
So,
no-
so yeah, so the question is, if you guys die, does your typical child have to have something in his will about his sibling? No. There's nothing in his will, nothing he does in his will impacts his sibling.
So what if he, that's my question, my asking is, if he has guardianship, he's been appointed guardians, God forbid something happens to him, then what happens to the ward?
So if you've named if you have two children, you've both died, your typical child is the guardian for the disabled child. The typical child passes away. Now who steps up? If you don't have other family members that mom and dad chose in their will, then it's APSI, or anybody can apply. So, and we see this, I see, you know, I remember I had a client at LAD and he didn't really have any guardian. There was a lapse in guardianship. And then one of the people at LAD retired and she applied to be his guardian. She couldn't do it while she worked at LAD, but she and he, they just had a relationship, a really good rapport. And so she stepped up and was his guardian for the rest of her life. You know, that was 15 years ago. She's got to be 80 now. But she stepped up and she was the guardian. She just has a relation. That's part of that circle of friends. So, yeah.
We have like 4 other besides our kids. So.
Yeah, you would name all 4 of those kids.
They go back.
Yeah, so if you've named in your will and you've done a power of attorney who you want to be the guardian of your adult disabled child, once that person doesn't do it, they just keep going back to your will to who's next. So, yes, you have another question?
Going back to family, we started with a lot of other alternative guardianship. All these different.
So the question was to recap, when do I think guardianship makes sense versus the alternatives? I always suggest, it's not my child. I can't stress that enough. You're the parent, you have to make the final decision. But my suggestion is, one of the questions I ask, if you say night, do they say day? You say moon, do they say sun? If it's that constant no, you're probably going to be forced into guardianship, because it's going to be, hey, will you consent to get your arm set? No, I won't. Not even because they're difficult, but because they just don't want to. But I think that you should try if it's possible to have a financial power of attorney signed, if it's possible to have a healthcare power of attorney signed, do that first. See if that works. Because it's not that long a process to get guardianship. Kids, even if something bad happens, I have a client who's in a really bad accident, no family, no one's guardian, because no one needed to be guardian. She was perfectly fine before this accident. And you know what? Like, the hospital just treated her. They did the surgery. They did this, they did that. They took her to rehab. I mean, somebody applied for Medicaid on her behalf. I mean, they just took care of her because she would die if they didn't. So they did it. You know, I mean, that's their job, is to not let people die. Even though she couldn't consent to anything, it was an emergency situation and she was going to have permanent harm if they did not treat her. And that's why I'm like, you know, nothing fatal is going to happen, because they're not going to let that happen, because hospitals can't do that. Had she been saying, no, you can't treat me, you know, they would have ignored her because she needed the treatment or she was going to die. So, you know, I say that I'm like, well, you know, roll the dice and wait it out, unless you realize that's not realistic. The other time that I see people who just can't wait it out is their child is way too gullible. And they're too easily controlled by anybody that they meet. And so they're very freaked out by it. Like, they've already seen problems with that. And now they want to be able to step in immediately and separate people. They want to be able to go to court on their behalf. They want that control because their child is just way too easily manipulated. And they will never, they are not going to make good decisions, because, you know, my aunt was like that. She was the sweetest person in the world. She would go with you and whatever you wanted, she would just do it. Okay. It was a disaster. I mean, you know what I mean? Like, you had to have guardianship in place. She was abused as a child because of that. was a different time also. She would be 85 if she were still alive. So, I mean, you know, but it was just, you know, it was not, she would, you know, she had to have a guardianship as soon as that was realistic, because we had to be able to keep people away from her and demand things very quickly. So those are the things, to me, those are the times when you're kind of forced into it. When they're just basically so malleable, anyone can convince them to do anything, or they're just so nonverbal that no one will believe that you're communicating with them and that you're representing what they want. So, all right. You are always welcome to contact me, email me, give me a call if you have a question. I'm happy to answer stuff about that. And if you need like direction on where to find court pleadings, I'll be like, oh, here's a quick link and stuff like that. So I do, like I said, I really do strongly suggest you kind of look at the trainings if you're going to do it, just to watch them. Even in the counties don't require them, I think they're very helpful to watch. So they'll answer a lot of questions that I'm not, you know, I'm talking about the general concepts, but there's nitty gritty in there. So all right, great.
Thank you, Laura.
You're welcome. Patty's going to talk to you guys for a minute now.
Yeah, so thank you everybody for attending a hybrid session today. We have people here virtually, we have people in person. I really appreciate Laura coming out and speaking to the dual groups. So again, if you walk away and you think about a question, she gave us her email or her contact information. If you happen to lose it, you can always email me and I'll put you in touch with her. Always you can go back to your SSA, and in different counties, there's a benefit analysis person. They might have a different title, but you can always inquire if you have questions too, and they'll probably reach out to Laura, you know, also depending on the question. But I'm going to go ahead and close the recording just in case someone here online wants to ask Laura something verbally. But I want to just thank everybody for coming, and thank you again, Laura, for your presentation.
Anytime.